That was a very different take. Welcome to the podcast. I don't even know what to say. I've been gone from this for so long. Isaac kind of quit on us, and once Isaac kind of quit on us, I haven't been doing the podcast, so I don't know. I didn't even know where my headphones were at. I didn't know where the mic was at. Like I'm having a hard time with all of this. Like this is like new again to me. So glad to be back. And glad to be with Brian DeBauche, attorney to the stars, amazing attorney, and he's going to be answering a lot of questions. This really came about by his name is Ryan. He had asked us to um, to get you back on.
Okay.
Him and a few other people wanted you back on. It's no exaggeration when we say a lot of people felt like the last time we had you on was probably one of the better podcasts. A lot of great information, a lot of good resource that you have been. So it's no brainer to kind of have you back on here and kind of answer some questions for the people. A lot has happened. A
That's true.
lot has happened with Bruin, Colorado laws. I think last time that we had you was about a year ago. And Colorado had the governor hadn't signed it, but it had it was going on its way to the governor. The Colorado getting rid of what's it called, preemption, getting rid of
Oh,
preemption. So
yep.
yeah, gun laws changing here in the state of Colorado. So a lot of stuff has changed. We're gonna have those conversations as people kind of come in here and get on. Please ask the questions. Ask the questions whether it be about the Bruin case, whether it be about something else that you would want to talk about. Um, but yeah, anything that you want to start off with, Brian,
Okay.
please, by all means. This is going to be mostly your show.
Well, so I'll start out with one of the things that I really commonly talk about, and that is all of the ways you can get yourself in trouble just by having a handgun on you and displaying it out in public. I've talked about sort of the mishmash of laws that you can end up violating and ordinances you can end up violating just by having a handgun and having it even accidentally displayed while you're out in public.
Yep.
And I talked about menacing, for example, which is one of the wishy-washy sort of ways they get at you. Public display of a weapon, that's one of the ways they get you. Harassment by display of a weapon, that's one of the ways they can get you. And by they, I mean law enforcement will, could potentially ticket or arrest you, and DAs are happy to prosecute you because, so, at least among a certain crowd, firearms aren't their favorite thing. Um, but what we have now with the Bruin case, and I know I had talked about this, I think last time, because I had sort of said this is going to be either a watershed case or it's going to tell us where the ceiling really is on this on the 2A rights. Um, and now what you have in the language of that case is uh, almost exactly what we were hoping for, which was an announcement by the Supreme Court that your right to bear a firearm, especially in public for self-defense, is a primary and essential right that was covered in the Constitution. Uh, covered in its very text. It has a historical uh, underpinning. Um, you read through that case, and they spend a lot of time and a lot of pages just going over the history of the limited firearms bans that they had at the beginning of the United States. But what this means, and I'm not telling people to go out and become test cases or anything, but what it means is a lot of the firearms laws, and by that I mean firearms restrictive laws that we have passed in this state, both cities and statewide. And I'm not talking about RMGO and their lawsuits about large cap magazines and that stuff. That's a separate discussion in a way. But what I'm talking about are just the criminal statutes that are used to first prosecute firearms owners and then remove, their right, for example, to get a concealed weapons permit after that, remove their ability to purchase a firearm potentially after that. Um, there are important um, sort of consequences to this decision that we're just beginning to understand and contemplate. You can see the the cases filed against the state and federal court and the way those have sort of gone so far. It's really too early to tell how that's going to all turn out. But the fact that they were able to uh, seek and be granted injunctions in those cases is important, because it means they were able to demonstrate uh, uh, possibility of success on the merits, irreparable harm if it's not granted. I mean, they had to demonstrate to a federal judge that those things were going to be true if the injunction wasn't put into place. And so the grant of that kind of injunction is an important step. It's not the end of the case, obviously, but it recognizes that there are very important interests at stake, and there's a pretty good chance on the merits that you're going to win.
Yeah.
So, what it's going to mean statewide is a substantial rethinking of all of those ticky-tacky little laws that I just talked about. Public display of a weapon being one of them. Harassment is going to have to be narrowed, because it will now, constitutionally, federally, constitutionally, uh, no longer be a legitimate law. And so
Correct.
the test cases are going to be some of the same folks I've seen over the years that same sorts of folks that I've had to defend and go to court and win on cases like that. But now we've got, an additional step, and that's a constitutional challenge from the get-go to push this thing in front of the Supreme Court here. If the legislature won't act, and I don't pretend to know what the legislature is going to do next session, but I don't imagine revamping firearms restrictive law are going to be among the top priorities. I doubt
Yeah.
it. I think it's going to come down to people going to court to challenge these things and then winning, and pushing those cases upwards until they hit our state Supreme Court, and getting the results of Bruin to flow down, to the state level. That unfortunately, is going to take time. Um, but that's the important consequence of that case. That's the important sort of result that we were kind of hoping
Correct.
for.
Yeah. And one of the things that you mentioned, and I appreciate why you mentioned it, but I think us as Guns for Everyone, we kind of want the test cases though. Like
Yeah.
you encourage people not to become test cases for obvious reasons, right? Morally, ethically, and
Hmm.
obviously a conflict of interest. But like sometimes it's important to have these people that fight the the government, because there's a lot of, I think we talked about this a little bit last time, is sure we get the Bruin decision, but Denver's still doing what Denver does because
Right.
nobody challenges them,
Yes.
because nobody puts them up against
Hmm.
the current decision. And one of those for us has been the privately made firearms. One of the interesting portions of that language is commonly used firearms. And so
Hmm.
we can carry commonly used firearms, right? That's under the protection of the Bruin decision. And well, privately made firearms became pretty common. But now we see a lot of restrictions against it. So I'm also curious about how that's going to play out if we can fight on that front. I know nobody's really talking about that because that's kind of at the bottom of the barrel, and understandably so. But unserialized, privately made firearms is also one of those commonly used firearms that people do use for self defense.
Hmm.
Have carried for self defense. Maybe not as common as a Glock, but it's still relatively common. Has become common in the last 5 years, anyways. So that's going to be interesting on that end as well. But
Right.
um, so it's that fine line of we need those test cases, or else nothing's going to happen.
Yeah.
So as Guns for Everyone, as Edgar, as myself, challenge it. And
Right.
notice I'm not going out there to go do it, so I'm asking you to do it.
Hmm.
But I appreciate why an attorney would say no, don't go do this. Is that fine line?
Yeah, I can tell you there's a pretty steady flow of those sorts of cases that end up in the court system all the time. And like you said, Denver does what Denver does. So the cities and counties in this state have not changed, any of their practices based on the Bruin decision, because their county attorneys are still digesting it and deciding if they have an immediate problem or not. But what I'm talking about is all of the folks that were getting those tickets before, hopefully, um, know about the decision, or find an attorney who knows about the decision, and they're willing to run off to court and challenge it and fight, instead of taking, whatever plea they're offered, no matter how benign, it seems. I the sloppy way some of those ordinances and laws are written, really throws a net over a lot of conduct
Yeah,
that should be constitutionally protected. And the only way to, if you don't stand up for them, don't count on other people doing it for you. I mean,
correct.
that's what happens. So, part of my job always, always, always is, from the time I start talking to a jury to the times that I come on your podcast or teach classes, 80% of my job probably is education, right?
Correct.
This is the way this is going to work. This is how the court system's going to, take you in and sort of grind you up and spit you out on the other side if you're not careful. And here are the steps you have to go through. A lot of my job is just getting the word out, or explaining how some of these systems are organized and work. And I appreciate, everything that Guns for Everyone does, quite honestly, because without knowing that this decision came down, and how really important and key it is to understanding what, unfortunately, what it is you're now able to do, without fear of prosecution, without knowing, that your rights now have been, I guess, recognized, re-recognized,
You're correct.
expanded from what they were before this decision came down. I mean, honestly, so you thought walking down the street you were a, a relatively free person with a set of, constitutional rights, and rights to privacy, et cetera, et cetera. And if it turns out, and until, five justices decide that you really do have those sorts of rights, they can be ground down quite a ways. And to your point about serialized both firearms and parts, we've seen, well, I've seen some of the videos that have been up lately with ATF agents knocking on doors, I guess using manufacturers or vendors lists to go after people who were mailed non-serialized parts that they now feel are either concerning or violate, certain of the regulations governing handguns. And so the what
You're
we
talking
have,
about the triggers?
yeah, the FRT triggers. So
Yeah.
the uh, so the same sort of thing happens with those regulations. So ATF has reams of regulations that you can sit and read through for days, and they make your eyes kind of pop out after a while, because they're tough to parse out. But you read, for example, the letter on the FRT triggers, and you read sort of what they're describing there. They've just decided to make a class of easily either printable or manufactured parts into illegal parts, and they're looking for people who have purchased them by going after, I guess, the manufacturers, and getting their mail lists for who was mailed any of those parts. And you think about Bruin. You think about Bruin and the historical analysis the Supreme Court did there, and why would, if you gave it a solid historical analysis, why would uh, your 2A right to defend yourself exclude any particular part just because it doesn't have a serial number on it?
Correct.
It's a major, it's a major problem. And so what's going to happen is, ATF regulations are going to send ATF agents to doorways. Eventually someone will be prosecuted for just, showing up on a mailing list somewhere. I'd be surprised if it happens that easily. I think it's going to be here's what's going to happen. So what's going to happen is one of those agents is going to show up at one of those doorways to someone who actually turns over the trigger, signs off on that destruction or forfeiture form, and admits they bought the trigger.
Yeah.
And there they have established, by someone talking to them about, this newly illegal part, by someone explaining everything that they did, suddenly they have admitted to everything they need to prosecute them, and that person will end up going to federal court on that violation of that gun law, and they will end up raising Bruin as a challenge to that particular law, to that, not law but regulation. They'll end
Correct.
up challenging the ATF on their own regulations and fighting them on it, but um, they're going to end up as a test case, and
Yeah,
that's
and
what I
and
mean.
and this is the weird thing, right? Like usually with stuff like that, we're always cautious because we've learned that we can't be emotional to what we see on the internet.
Right.
But there was one time I woke up in the morning and I had a text. I won't say who it was, but I had a text from a friend. He says, "Call me now." So I called him up. He says, "Hey, we this person so and so, no knock raid at his house,
Wow.
um, and it was over privately made firearms." So no knock raid. They took him in, trying to figure all that stuff out. Right, we were kind of gathering as a community to start the. Uh, we don't use GoFundMe anymore. We use the GoSend Go or whatever the other
Hmm.
funding crowdsourcing is.
Hmm.
Trying to get that ready. So now we see it personally, right? With the FRT triggers. I know somebody, you know somebody very personally that is kind of worried about being on that list. And we actually have a mutual friend who was contacted by the ATF. Well, his wife was contacted by the ATF, and they told his wife essentially, your husband's a dirtbag, committing all kinds of crimes. But in reality, all he did was buy a what was a legal FRT trigger, which a FRT trigger is for your AR. It turns it into a kind of a binary trigger. I mean, those that know what it is, we're just walking the fine lines of language here so that we don't feed into the beast.
Hmm.
Um, so it turns into a binary trigger. There's binary triggers out there that exist that didn't, but for whatever reason, the ATF wanted to make this trigger a fully automatic. It consider a full auto gun, which is not the way it works.
Hmm.
It's you and I both know that's just not the way it works. But the ATF does what the ATF does. All that to be long winded and say it's not just internet stories. Like the ATF is really out there, and they're making the phone calls, and they're watching what you buy, and at any moment you do something legal, and if they change it, right, this new privately made firearm stuff changed on the 24th. I wonder how many people actually know that it changed on the 24th and we're
Hmm.
sitting on a privately made firearm or a frame, and then now can't really convert it into a gun because they bought it after the 24th, and they're going to post it on social media, and the ATF is going to come talk to them. What do you say to people that are in that situation other than hurry up and call you? I would say if you have an FRT trigger, call Brian tomorrow morning,
Hmm.
uh, and start making those decisions. If you have a privately made firearm, contact Brian because I mean, no knock raid. This guy, it's basically the vagueness of the law, right? There's
Hmm.
some cities and some states that say for privately made firearms that they want you to make a marking on it. Well, some agencies may want a very specific,
Yeah.
traditional looking serial number, but you put "fuck the ATF" as your serial number. they, they may not they may not see that as a serial number, although you are in compliance with the law. So that's like
That's
the
right.
the catch 22 where
That's
I'm
right.
in compliance. I marked it. You said a marking, and here's the marking. Um, and my understanding is that's a little bit about what happened to the guy that had the no knock raid. I'm not giving too many specifics because I have very few, so I'm not. This is information that I've got from the friend who got the phone call. So and even then, this was last week. So like, don't take this and be like, oh, this is exactly what happened. I'm just giving you a general idea. One, to not feed the beast and not get misinformation out there, and then the other to protect the individuals that this is happening to.
Right. 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 Yeah. So, standard advice, if ATF were to show up on the doorstep, is first of all, I'm not answering any questions. And that's immediately going to probably make them angry, and they're probably going to threaten to prosecute you, and they're
Correct.
probably going to, get louder, and use the command voice, and try and get you to answer questions. But if they're not standing there with a warrant signed by a judge in their hand that they can show you, they're not coming in. You're not answering questions, and you're not going to admit whether the a particular part is inside your house or out in the garage or burned up in a fire or anything else. You don't have to answer any of those questions. You're not required to cooperate with the ATF. You're not an FFL that has to report certain, for example, multiple gun sales. They have to report multiple gun sales. You're not under that same obligation. You're just Joe Citizen. You're just sitting in your own house, and when the knock on the door comes, you can ignore him if you want.
Yeah.
You can talk to him through the mail slot if you want. You can go outside. I mean, you got to watch for the foot in the door trick, but you can go outside to talk to them if you can get them to back up. But don't let them in the house, because once they're in the house, problems ensue pretty quickly. I saw a video, and one of the immediate issues they raised was get your hands out of your pockets. And the guy's response was, this is my house. I can put my hands in my pockets if I want. Get out of
Correct.
my house. Once they're inside, it's too late. Don't let them inside. Don't let them inside the house. If they want to stand on the lawn and talk, that's great. You know, Otherwise they got to get off the lawn and you'll talk to them on the sidewalk, but they don't get inside the house, not without a warrant.
Yeah, and that's the hard thing for a lot of people, and it's a hard message to convey. For me, I try not to do this during gun classes because you're walking a really strange line. But definitely, person to person, and definitely here on the podcast is sometimes it's not a bad idea to just get arrested. Sometimes
Right.
it's not a bad idea to just hurry up, put the cuffs on me, because now you're forcing them to start the process, right? Like, hurry
Hmm.
up and charge me. Like, you're asking questions. Like, if you're gonna charge me, let's hurry up and get that going. And a lot of times when they have no evidence, they have nothing to charge you on, and they just look like a bunch of idiots. Which can start some other fun games but for a lot of people, like, I got to go to work, I got to pay the bills, like, which is understandable, right? I get it. I don't fault people, but it's sometimes it's not a bad idea to just for a few hours go spend some time. They're gonna feed you. They're gonna get you a Coke.
Right.
Ask for as much as you possibly can, and you can shut the fuck up there. And
Yeah.
but at least I don't know if this is the correct thing, but like I know I've been in a position where it's just either charge me, let me go, or let's go downtown. Like, hurry up
Yeah.
and make up your mind instead of playing these games. If we're gonna do this, let's do this.
That's right. And the next question, depending on what they tell you, is, am I free to terminate this conversation and
Correct.
leave? Am I free to leave?
Yeah.
Because then you're not under arrest. They're not detaining you. They're just talking to you, and it's voluntary for you to keep talking. And if you keep talking, you're volunteering that information. You
Correct.
you know you, I suggest people shouldn't, but you keep talking. It's voluntary.
Yeah.
Um, let's let me handle Robin's question real quick. So Robin asked if I gift a rifle to my daughter who is over age 21 and no criminal record, what is the procedure I should follow in Colorado? So the
It's
the
eight
law
eight.
on gift, yeah, it's 12 112. So
Yeah.
it's gifts to family, immediate family. Um, so kids, spouses, parents, that kind of thing, immediate family. You can gift the rifle to your daughter if the daughter has no other precluding fact, no convictions for domestic violence, not a habitual drug user, certain things you may or may not even know. But if this is a daughter who has no criminal record and is over the age of 21, you can transfer that firearm freely to her, as long as she's actually your daughter. And I'm going to say probably not stepdaughter, but definitely adopted daughter would count, because that becomes an immediate member of your family. Um, so no problem. There's no procedure to really follow. It's non-immediate family members. So you give it to your first cousin twice removed. You probably have to go through an FFL. You give it to,
It's up to
someone who you call your
first
cousin.
cousins.
Yeah, yeah. If you call someone your cousin, but and they're not really related to you, yeah, you got to go through an FFL. So it's not that restrictive, but little bit of a pain when it comes to some of the mixed family situations that we have now.
And if I'm not mistaken, Actually, I know I'm not mistaken, but let's cover it. Even if she wasn't 21, you can still gift her um, the rifle and even handguns. If I'm not mistaken, they can't buy the handguns, but I think at 1812 Part 1, it states that if you're under 18, you can't possess a handgun.
Handgun.
And
Mhm.
yeah, so yeah, so it's good information right there. Um, so back to what we were, and if you guys have more questions, please by all means bring them in there. And obviously, Brian's paying attention more than I am, so please by all means do so. And I'm going to take this opportunity. If you go to our Instagram or our link tree, we do have a link there so you can donate to Brian and our quote unquote legal fund that just helps him eat and pay for his Ferraris and all that shit.
Oh man.
No, no,
Yeah,
no.
yeah.
That helps him
Not a
keep
first.
in the fight. Uh,
Yeah, I wish.
yeah, yeah, absolutely, absolutely. If I'm being completely vulnerable, we're a little late on paying him, so hit that donate. Donate to him. He's helped us out a lot. Brian is somebody that you guys want on your side. He's great at what he does, so always appreciate him on here. So go show some support. But yeah, if you have more questions, by all means, please do so. Ask those questions. But anyways, we were saying about the FRTs and the no knocks and
Hmm.
ATF.
Yeah. So luckily, luckily, well, it's hard to tell how much of that is going on. It's odd the timing that's been chosen to go after those sorts of items right now. You know, you would think there would be other priorities nationally, but maybe not. It is odd that they're going house by house, confronting people when they know the word's going to get out pretty quick that that's what they're doing, and there's going to be, a lot of resistance to it, not just spontaneous, but sort of organized resistance to that kind of move. Um, it is. Odd to see a post facto law like that or regulation like that just pass. They just decide that they're going to forbid a certain class of items that have been legal for so long, and then you look at what they did in Colorado. They grandfathered all those prior large cap magazines, so there are so many in existence that they've stipulated there's probably tens of millions of large capacity magazines in circulation. It's difficult to effectively regulate large capacity magazines as a result because there's no way to prove unless they're serialized and actually tracked. There's no way to prove when those were manufactured and when those were last
Correct.
bought. It makes it almost you know a futile law. Basically it's a silly law because you can't enforce it, and Denver's had problem after problem with enforcing that same kind of law. Now ATF is doing the opposite, right? They're saying, well, if you have it, you are you are now violating the law because we
Correct.
say so, because we issued an open letter and we've decided that that's the case. It's not legislation. It's not even widely known. I mean, you got to go look for the stuff that they've published a little bit
Correct.
to find it. It's not part of an announcement that would be required for an administrative regulation to pass. So it's not a rule. It's just a change. They just changed their mind.
Correct.
And
So
so that.
where does that put us then? Is in constitutionally where they could just they're making up arbitrary laws and essentially turning good citizens into felons almost instantly. A
Right.
lot of these people admittedly don't care because they're okay with pushing back and preserving that quote unquote rebellious thing of the US, not because it's a criminal thing, right? You made me a criminal administratively. I'm
Hmm.
not an actual criminal. I'm not hurting people. I'm not stealing from people. I'm not doing any of that stuff. So that it
Right.
puts a lot of these people in a position where, like, well, if you say I'm a criminal, then let's do something about it. And then there's other people that would have never chosen to be a criminal, and now they're in this position where I have this thing, but
Hmm.
this letter says I am now a criminal just by possessing this thing. So if I take it in and I don't take it in, so it puts us in this weird position. So I guess the ultimate question is constitutionally, what gives the ATF? When did that happen for the ATF to be able to just write laws? And I think that has a little bit to do with like the EPA and all that stuff, because they kind of do the same thing, where they just make shit up as they go along.
Well, so there's a couple different layers to it. Let's start with the first one. The first one is usually if they're going to announce a new rule, and this goes with this applies to PUC in Colorado, it applies to the EPA federally, it applies to the ATF. If they're going to make a new rule, there's usually a draft rule, a commentary and public notice period. There may be hearings on the new rule. They eventually pass the new rule, and then it has an effective date. It's going to go into effect 6 months from now or 3 months from now. It's going to have an effective date, much like a piece of legislation does. Goes through all kinds of discussion. When it passes, a lot of people know it, or more people than would know about this letter. That's the ordinary process, and we don't have any of that happening in it with the ATF and FRT triggers. So it makes less sense to try and impose criminal liability on someone who is only now learning, when you show up with handcuffs, that they are violating a law that you made up a couple of weeks ago. And not that you made it up, but you decided to reclassify certain items that they purchased legally before,
Correct.
15 days ago, suddenly became illegal to possess 14 days ago. And it's like a 10-year sentence guideline, like it's a 10-year stint on for what they believe to be an item that turns an AR into a machine gun, is what they're saying. So it's a fairly serious set of penalties for something that they just decided to stick in a letter and publish on the internet. There's a lot of stuff on the internet, but that doesn't mean a whole lot of people are going to find this thing. It also doesn't mean that there was ever an opportunity to discuss it, challenge it, have hearings on it,
Correct.
bring up Bruin, and ask them how they believe that an agency, not Congress, an agency can switch a definition like that on their own in the face of something like Bruin that says if you have an ordinary firearm or an ordinary firearm part and you're using it for self-defense, that somehow it is now in the class of offense, class of conduct that can become illegal in the face of something like Bruin that says you have a 2A right to defend yourself. Um, so there should have been a process, and there should have been more time to go through that process. But one of the things you're pointing out is when you talk about the EPA and the way sometimes they issue the same kind of thing, something draconian comes down from them as a decision about what they're going to prohibit, and everyone's just got to snap to. The issue with that is, or has been recently, that some of the courts are starting to push back on that administrative state. So ATF, uh, the regulatory agent, you can think of DOT, DMV in the state,
Correct.
PUC, all the boards and commissions under DORA, they all have their own rules, sets of rules that you have to go looking for. But the pushback is, in this case, did Congress authorize the agency to make a post facto redefinition of an item into a crime? And it's not likely that that's in their authorization, right? It's not likely that that was within the scope of what they're allowed to do. And so some of the challenges against those sorts of actions have gone to court and gone to different circuits to challenge the scope of what the agency is even allowed to do, and fighting them on that basis. But that requires, it doesn't require a test case necessarily. It just requires that you have some standing, and then you can file a case much like RMGO did, where you challenge a specific law and ask for an injunction and a declaration of what is the scope of what this agency is allowed to actually do, without Congress either amending the scope of what it said it was allowed, or uh, creating the definition themselves because they're Congress. I mean, that becomes the
Correct.
sort of second layer. And then I think third layer is going to be just individuals and what
Yes.
they're able to muster against a potential prosecution or just investigation, and how much pushback you can give the agency on something like this. Um, I think that's where most people are going to be when they get the knock on the door.
Correct. Yeah, that's man. When I heard about um the friend who had his wife call, the ATF called his wife and started telling her about how her husband was such a horrible human for violating this law. And obviously she's frantic, she's trying to figure out when the
Mm-hmm.
hell
Mm-hmm.
my husband just got into. And then I'm sure when she found out, she's like, what the fuck is this? Like, that's
Yeah.
like, I'm over here thinking you just killed someone, like you just did something horrendous. But it's a silly thing, right? It's nothing that's it. But the tactics that they use are, they're I mean, and I don't know if this is standing is borderline inhumane. Maybe I'm being dramatic because I like the
Mhm.
FRT triggers and stuff like that. But these tactics that are unethical, really. Telling someone's spouse that their significant other is committing crimes at a federal level
Mhm.
that can come with the penalty of 10 years in jail and that type of stuff. Like, your mind is, you're thinking something absolutely horrible happened,
Yeah.
and
Right.
it's not. Like, it's just not.
So it's unprofessional, is what I'd say. If their profession is law enforcement and
Yeah.
they're ATF agents, there should be a professionalism requirement that they um, engage in those investigations in good faith and they respect citizens, response if they object to questioning and decide they don't want to cooperate. That's it. Turn around and walk away. You don't get insulting. You don't call the guy's wife up. I mean, the mafia goes after your family, but the ATF should not be one of the folks that goes after your family to try and pressure you, because that's in essence what they're doing, right? Pressure you. If we
Wouldn't
panic,
that be a violation of the Fifth Amendment as well?
not really. Not a violation of the fifth, but what it is a violation of the 14th, because what you could say is it's a due process right that I have against investigations of that kind, and my family has the right to be left alone, and you don't have the right to call my family members in order to try and question me. You
Got it.
you have the right to question me. Ask me if I want to answer any questions, but you don't get to go to my friends, family, and associates and talk to them about what a POS I am. That would seem to violate just ordinary professional standards for investigation.
Yeah.
And but unfortunately, you get all kinds. You just like you get waiters and waitresses and service industry
Correct.
employees who are decent at their job. Sometimes you get people who are bad at their job, and sometimes you get the ATF agent who had a bad day or he's going through a divorce or who knows what the hell happens. But um, as a consistent practice of what they're doing is going house by house by house, running down these lists of manufacturers mail orders, and then questioning the people they find at those houses. They are doing needle in a haystack sort of investigation, right? They don't know where that trigger ended up. They don't know how many times it was resold. They don't even know if it's still inside the household.
Correct.
I'm assuming what they have is they went to the manufacturer and subpoenaed or secured the lists of mail orders, and then they went through those mail orders and decided where they were going to go and start pounding on doors. But I think the response is I'm not answering any questions. I've got a lawyer, and you can talk to him, but I'm not talking to you on my porch.
Correct. And as a reminder, if that's you and you're here in Colorado, especially in the Denver metro area, and you got one of these triggers, or you've got a privately made firearm and you got questions, please get a hold of Brian, denverlawshark.com. That's the website. You have all the information there.
Hmm.
You get a hold of him there. Um, pretty responsive as well for a lot of this stuff. So um, the other thing is that you touched on is the RMGO cases.
Hmm.
Um, I've been pleasantly surprised in the RMGO stuff and what they're doing. We used to be indifferent about RMGO just because for a while there it just seemed like they would just take your money and really not do a whole lot. And then when something happened, they would come in the fourth quarter, last second, and then they say I'm the one that scored the touchdown. Uh, so so that was traditionally what we were used to, and then you donate, and then they'd say, we hate gay marriage. Is like, that's not what I gave you money for.
Hmm.
Whether you agree with that or not, that's not what the hell we gave you money for.
Yep.
And now it's under different direction, different leadership. I also believe Dudley has had a change of heart on the national level, but now we've got this individual by the name of Taylor Rhodes, who's heading up our MGO. And Isaac and myself, we got an opportunity to have dinner with him, and he seems like he's really taking this down the right direction, the right path. It's not just lobbying now; it's actually um, going the way of FPC, which is more let's actually use our members' money and do what we said we were going to do, and
Hmm.
that's these lawsuits. One of them is out of the town of Superior, if I'm not mistaken. They sued them. Um, do you know where that's at right now? I know it's not your case, and I know it's
So federal court moves fast and slow compared to state court. It moves fast in the beginning because they get you into court, get you scheduled for hearings, issue a case management order and a discovery order, and then they leave you alone. And then when you come back with that stuff done, then they'll set a trial date for you, but it'll be a year away. So,
because
uh,
right now they blocked the law, right? The
yeah. So that was sort of general information. Here's what
Yeah,
happened in their case. So they filed the complaint, served the defendants, which was the state and Jared Polis and the city of Superior, and so they identified the defendants. They filed a complaint. They served them, and then as part of that initial complaint, it looks like they drafted up a motion for a preliminary injunction that requested that the laws that were on the books about, for example, large capacity magazines uh, they would be enjoined from enforcing those laws until the uh, complaint had a chance to be properly litigated, and they can halfway through decide that they're going to challenge the injunction again, because this is just a preliminary injunction. It's
correct.
just in place to preserve the rights of the plaintiffs, just in case they would be losing those rights in the interim, or have impact on those rights in the interim. So complaint was issued and served, answered. The injunction immediately went to what looks like a fairly short hearing, and the order came out granting the injunction just until the complaint can be handled or developed a little further along. So I don't think the case has even gone to case management conference, which would be the next step, where you set deadlines and
Got it.
discuss how much discovery you want to do on the issues in the complaint and the answer. But the complaint that I read, at least, was fairly straightforward, and the one I the one I read kind of carefully, was the one against the state about large cap magazines, and just said, well, basically, um, large capacity magazines were banned, and there was a prior challenge that was turned down. But we have a case called Bruin now, and Bruin seems to say we have a Second Amendment right to ordinary firearms and attachments and magazines, for example. And 15 round magazines are not uncommon magazines. They're not extraordinary. It's not a 45 round banana clip or a drum or anything. It's just a 15 cap magazine. 15 round capacity magazine. Why is that?
Well,
Why does that become a problem?
in fact, a 30 round magazine is a lot more common than a 15 round magazine.
Hmm.
Yeah, yeah, but yeah,
So uh, all they were doing was just running down what Bruin should mean to a prohibition like that now. If it's an ordinary, sorry, if we understand from history and then the development of firearms after that original history, we're not just, being allowed our muskets, we're being allowed ordinary
correct,
firearms for our private use, then we should be allowed ordinary magazines for our
correct.
private use. um, you know, uh, and so the challenge was straightforward, and all they were really asking for was a declaratory judgment. It just said declare essentially whether we're right or they're right. If we're right and Bruin says I can carry any ordinary magazine, including 15 or greater, then their law has to be struck down and permanently. They won't be able to resurrect that thing unless they want to try and ban gigantic drums of ammo or something that attach to actual machine guns. Like they're going to have to justify any future restrictions and
Correct.
jump over the additional hurdle of explaining why uh, they want to ban any particular firearm part, magazine, shotgun tube, whatever you want to talk about from now on. They have to jump over Bruin as well. And why wouldn't an ordinary citizen use something like that for self-defense?
Yeah. Yeah, that was kind of that was kind of good to see the kind of that direction that was going. And traditionally in Colorado, that's not the way it goes.
No,
One of
it's
the
not.
reasons why the FPC, which is a great organization that sues a lot of people, they tend to shy away from stuff here in Colorado because the 10th Circuit has never been traditionally a good way to the Supreme Court on any of these cases. Uh, Ironically, the Ninth Circuit, which has California and it has been an
Mhm.
easier way, an easier path to the Supreme Court, which is kind of weird. But the 10th for gun stuff has always just been that stall, and we've seen it in 2013 when RMGO kind of challenged the initial stuff,
Right.
kind of went nowhere, and now to see a very quick block of the town of Superior. I don't think they blocked the state, but I think they initially blocked the town of Superior at least. Or I'm not sure if they added Boulder and the state of Colorado to the same case, but I would imagine that's not the way it works. Um, but it was definitely a nice change to kind of see on uh, on that side of stuff, especially through the 10th Circuit,
Hmm.
which is where we're at. So it's nice to see where this is going. Hopefully, it heads in the right direction, and also hopefully it stops any further attempt here in the state of Colorado, because the Bruin case basically stops them from doing almost anything. Not everything, obviously, but almost anything in terms of restricting your right to carry a firearm for self defense.
Hmm. Yeah, and almost any handgun, and really almost any firearm. The one thing they did talk about was dangerous and unusual weapons, um, which I think historically were I don't even know what those would be that far back. But that was the only real prohibition they had. So I think they're talking about short shotguns. There's a couple of other examples in the law here of particularly dangerous weapons. Um, Gravity knives, switchblades, kind of silly things when you get right down to it. Um, because there's nothing particularly dangerous about one knife that isn't true of all knives,
Of
right?
all those,
They're all uniformly sharp, and they can all uniformly do almost exactly the same thing, and they don't do it differently from one knife to the next. Um, but that was the only thing they really discussed. I'm actually looking at the opinion right now because my notes are in here, and I thought I noted maybe they talked about um, limited regulations of firearms in sensitive places. Um, they talked about that and whether firearms would potentially be allowed in school and government buildings. I think it's one of the discussions they had.
yeah.
Um, they treated it as settled that sensitive places could have a firearms ban, but that is specific to a place like a school or government building.
You're talking about
Now,
on the federal side?
yeah.
Yeah.
And so, does that impact Denver's recent ordinance prohibiting concealed carries in a park? Now, if you've been to Central Park in Denver at night, it is one of the most common places you might want to try and have try and protect yourself because City Park gets scary. Central Park gets scary at night. And should you be allowed to carry firearms to protect yourself in particularly scary locations? And does a public park constitute a sensitive place? Probably not. It is not a
No.
sensitive place. It's a park, right? It's not it's not a school, for one thing, where you'd have a vulnerable population. It's not a government building where you might have sensitive data or documents or sensitive personnel. You don't have that same sort of concern in a park or a zoo, or a thoroughfare or anything else. It's literally a public park, and by public I mean any member of the public can go in and out of there without passing through a metal detector or any other security. So
Correct.
should you be allowed? Is that going to be struck down? Probably, right? Probably.
It would almost have to.
Yeah,
It would almost
have to.
have to. So I'm going to answer Robin's thing and just kind of add mini 14s have never been discussed in the AR-15, AK-47 conversation. Because a lot of those guns, they don't, for political reasons, right? A lot of the stuff is just politically driven, and it's just a lot of the stuff that they see on the TV. Um, so now Denver does have an assault weapons ban that is magazine specific. It is not necessarily AR-15 or AK-47. Um, it is magazine. So I think even in the magazine ban, an SKS with a 30 round magazine in Denver as a Denver resident, you would be considered to be in possession of an assault rifle, which is magazine specific. Though Denver's law is so weird, though. It's pretty, and it only applies to Denver residents. So it's not a
Really?
Colorado. Yeah, it's not a Colorado thing. I'm gonna pull it up here. I'm gonna go to Municode. Um, Unicode, and I'll put it up on the screen here.
That's so. Yeah. That is a knee-jerk reaction to something they believe to be a problem, but isn't actually the problem, right?
Correct. As most laws are. Let's see. Assault. First off, I need to know how to spell assault weapon. Let me share. They changed this again. Oh, here we go. So here's in the Muni code. I don't know if you can read it. Can you read it?
Yeah, I could blow it up to full.
Okay.
Affirmative defense. It shall be an affirmative defense. You got a permit and you're transporting through the city.
So, here we go. Large capacity machine feeding device prohibited shall be unlawful to store large capacity ammunition. But what I want to get to the point where what an assault rifle is. Unlawful weapons. The definition.
Should be up above then. If it's not in the very beginning of that ordinance, then it's right above that, probably in a definition section. There it is. Assault weapon. Right there.
You found it?
Yep, right there. Assault weapon means
Oh yeah.
any semi-automatic pistol with more than 15 rounds, any semi-automatic shotgun with a magazine capacity of more than 6 rounds. I guess I haven't read this.
Now, again, this is only for Denver residents. It does not apply to me that doesn't live. So I can go travel through Denver with my AR-15, 30 rounds, because this is Denver specific for Denver residents. But
6
yeah,
rounds. Isn't every Remington 870 like a 6-round shotgun? Like, I mean,
it depends on the size of the
tube. Yeah.
the tube. It depends on the size of the shells that you're using.
Okay. So if that's the definition, any semi-automatic pistol with more than
Any
15,
semi-automatic,
any
yeah.
shotgun with more than 6, blah blah blah. Assault weapon does not include. Oh, there's a bunch of definitions that don't apply to really anything. Okay, so assault weapon, if it's pistol or centerfire rifle with more than 15 rounds. Now go back to that ordinance down below that talks about the actual ban. Keep going. Keep going. Keep going. Dangerous carrying. Keep going. Assault weapon. There we go. Possession is unlawful. Unlawful to carry, store, keep, manufacture, sell, or otherwise possess assault weapons. Except it doesn't apply to any federal, state, or local government agency or sworn members of law enforcement. Any person in possession of assault weapons being used as a movie prop. Affirmative defense. Through the city by a non-resident who is in legal possession of an assault weapon. So, Edgar, I'm going to change. You've heard me say this before, but I'm going to tell everyone this. So it's illegal for a non-resident to carry that assault weapon through the city. It is an affirmative defense to your arrest, charging, court appearances, conviction. It's an affirmative defense to all of that you were a non-resident moving through the city with that weapon.
Correct.
So that means you're going to get ticketed, go to court, hire a lawyer, schedule a trial date,
Correct.
fight with the city attorney. Day of trial, if you go in there waving Bruin around, they might dismiss your case on the day of trial, or they're going to see if this, citizens of Denver will convict you, even in the face of that affirmative defense. That, practically speaking, is what's going to happen if you're a non-resident.
So if you're a non-resident, if you affirmative defense, if I'm understanding correctly, this is a great conversation to have.
Yep.
Because I've always just read it and just said, oh, like it's legal for me to do. But you're saying, sure, it's legal if you're willing to go through all this shit and fight for it.
It's legal if you're willing to go through all that shit. And you're gonna leave it to 6 Denver jurors to decide whether or not the affirmative defense applies to you. But clearly it would. You're a non-resident, you're traveling through the city, you're in legal possession of the assault weapon. So it should be no-brainer.
So there's a difference between shall not apply to and affirmative defense.
Yeah.
So what is I guess in a more professional manner, what is affirmative defense?
So an affirmative defense is like defense of self-defense. It is like the defense of duress. An affirmative defense is a defense you can use where you assert the defense and they have to disprove it.
Got it.
That means all you have to do is have some evidence of it, and they have to disprove that that's the case. If they can't disprove that the affirmative defense applies, you win. You're done. You're acquitted. You're out of there. So if you and I get in a fight and I say he started it, and you say, yeah, I started it. I punched him in the nose because, whatever.
Correct.
Insulted something. And so we go to court and you admit that's the case. Clearly I'd be defending myself if I'm reacting to your attack against me, and it's up to the jurors to decide, even if there was an assault and even if there was this fight, even if Edgar was hurt, there's no crime here because it was in reaction to a self-defense situation. So same thing applies here. You assert the self-defense of non-resident, they have to disprove that at a trial, which they almost unless you're mistaken about your address, they couldn't do it. Like there's some portions of Commerce City that you think are, Adams County and they're Denver. Right. There are those crazy zip codes that may or may not land you inside the city limits. So those are gray areas for people. Yeah. You got to know where you live, I guess. But otherwise, a non-resident should be able to travel through the city pretty freely with an assault weapon. Yeah. So you're right in one important way, and that is you were right that the law really should not apply to non-residents. They shouldn't be ticketing non-residents for traveling through the city with an assault weapon. And then it says a person carrying a permit issued under subsection E. So this must only apply to Denver residents.
Correct.
Because non-residents wouldn't need the permit. And so what it should say is by a resident carrying a permit under subsection E. And so the conditional exception is, looks like serial number, apply for a permit, police department issues you the permit, and then they have to identify the assault weapon and where it is to be stored. Do you see that down below in E4, E3 and 4?
So that's in violation of state law though, right?
No, it's still the ordinance. Still the ordinance.
Because the said assault weapon was probably identifiable and contains its original serial number. Okay, so it's not like the Boulder one where they try to have you take it down to the sheriff's office or police department and get a certificate for your certified AR.
Yeah, right. A permit, no kidding. So if you're in Denver with an assault weapon, which is any semi-automatic weapon capable of firing
semi-automatic rifle,
or more. Yeah. Well, no, it said handgun. So if I have if I have one of those little
What?
Ruger, yeah, it said handgun. Go back up in the
No.
definition. Yeah, look up right there. Semi-automatic pistol right there in 1A. Any semi-automatic handgun with 15 rounds in it. So your little,
Or center
Ruger Mark
fire.
III, yeah, your little Ruger Mark III with 18 rounds in it because you go to the range with it and you fire 18 rounds at a time. That's an assault weapon in Denver for the residents.
A shotgun. Any firearm has been modified. Assault weapon does not include any of the following firearms that do not use fixed cartridges. Firearms that are in production prior to 1898.
1898.
Any pump action firearms, single shot weapons, multiple barrel weapons, revolvers, semi automatic weapons for which there is a fixed magazine with a capacity of
Have
15
less than
rounds.
15.
Uh, wow.
It yeah the yeah that's why when you told me that, I wanted to see this sort of in detail because you read through these things and you think, okay, match the definition to the ordinance that says I can't carry that anymore, and then you start reading through, and I I I have to remember, but I think some of those Rugers that I think I've got a Target Ruger, and luckily I don't live in Denver, but I've got a Target Ruger that holds more than 15 rounds, and it's
Yeah,
semi-auto. You could plink away at paper targets all day with that thing.
that's crazy.
A little bit, yep,
So I
a
knew,
little
but
bit.
I knew it was rifles in general. I knew it would have included the SKS or the Mini 14 or that type of stuff. So I was certain that it was that, but I apparently missed that it says any automatic pistol.
Hmm.
Sorry, I'm sorry, semi-automatic
Semi-automatic
pistol.
pistol. Yeah.
Wow, that's crazy. Denver. I wonder when they updated this one, but that's a lot of reading. But for those of you guys that are interested in your city laws, now that Colorado doesn't have um, preemption, Muni Code is a good source, or maybe plug your ears because isn't part of the new preemption that if which is one of the very first times I've seen it, where if they have to prove that you knew the law existed. We'll have to read that. Um, but if you get caught in one of these new places that Boulder's banning, or I think the law says that they have to prove that you did not know, or that you did know. I'm sorry, that the law existed. So one of the very rare times where ignorance of the law is probably a
And
benefit.
is that apply to residents or non-residents?
No, this is
Like,
the state law. This is
hmm,
the state law.
okay, yep.
Yeah, yeah. So by me telling you go read the law is probably
Go read the
probably
law. Yeah, go read
yeah,
the law. That's exactly
yeah.
right. That's exactly right.
Um, so is there any other legal stuff? Any other? I know you and I before we came on, we wanted to. I had asked you some questions, but I think we should leave that for a separate. Allow you to kind of prepare your notes a little bit more, and I'll send you
Hmm.
that. But is there anything else that you wanted to kind of have a conversation about and share with the public
Yeah.
and make sure they know? Yeah, go for it, man. This is your show, dude.
Okay. Yeah. So one of the real common things that I get calls about is, can I get my firearms rights back?
Oh
And
yes.
this comes up a lot, a lot, a lot.
Hopefully, mostly from us because we get that
Yeah,
question a lot.
a lot. Yeah. And so I get those questions all the time. And someone says, I've got this felony case that's 24 years old, but it really is a felony. Um, and so p- separate from that question is, what's the impact of sealing, expungement, or something like a pardon? And so folks think that if you seal your case, the sealing laws have been expanded, pretty drastically over the last 10 years or so that you can seal an awful lot of cases now. You can seal almost every municipal case, and you can seal a lot of the misdemeanor state convictions, and you can seal, even after a long period of probation and clean behavior, even felony convictions. You can
Correct.
seal them, but sealing is not expungement, is not a pardon. And what I mean by that is, sealing is just a way of closing that case up from public view so that the public can't find it, employers can't find it, apartment managers, when they're looking at your record, can't find it. It's sealed from public view. And that means the record of the arrest, the record of any conviction, the record of probation, the court case itself, like all of it's gone. I mean, gone, gone. Like if a court enters an order sealing one of my cases, I literally can't see it 30 seconds later. If they enter the sealing order, I can't see it anymore. It's gone
Yeah.
and gone, gone. But law enforcement can always find it. CBI
Sure.
can always find it. If you think it's sealed and you think you're in the clear, sometimes you're not. And by that I mean if you have a, a a conviction that precludes firearms possession, it is still there for CBI to find, for the feds to find. Everyone, that needs to can still look it up and find it and decide that you cannot purchase or own or possess a firearm other than for self-defense in your home. And I've made this point before, but that's a specific exception in Colorado, at least, that you can defend yourself inside your own home. Now we're going to talk about Bruin in a second, but let me move to, so we talked about sealing.
Correct.
Expungement. People think you can expunge a conviction, an adult conviction. You can't. Expungement is reserved for juvenile cases and juvenile delinquency cases, which are not really criminal cases. Juvenile delinquency cases are quasi-civil cases where the sort of the best interests of the juvenile are at the heart of the matter and not really criminal liability and punishment and deterrence. It's really about rehabilitation of the juvenile and what can we do to turn that individual around. They get to expunge their record after a period of time, sometimes as long as 7 years after the probationary term ends. But you get done with your probationary sentence or whatever you end up doing for your juvenile case, 7 years later, no later than 7 years later, you can expunge that, which means it is wiped off the map, like gone, gone. And sort of importantly, along with that, juvenile adjudications, if they are for precluding felonies, will preclude you as an adult from possessing a firearm.
Yeah.
So, in order to get rid of that, you have to expunge it. That usually, sorry, as far as I can tell, if you expunge it, it is wiped out like it never existed. And as long as you can expunge it, as long as it belongs to the class of juvenile adjudications you can expunge, you might be able to reinstate your firearms rights if that is the only thing keeping you from possessing a firearm.
Correct.
A pardon is like the nuclear bomb of it's the end of the argument completely, because if you can get a governor's pardon or you can get some form of clemency, um, and you can get your conviction wiped out, it is like an expungement for adults, because it wipes out and pardons you for that crime and eliminates it, and then you can reinstate your firearms rights that way. But it's difficult to do that. You don't see a lot of those pardons granted year by year. And it isn't just for run-of-the-mill Joe Blow. It's usually for people who've got some community involvement, and they have some investment, and they are recognized as beneficial members of the community, and they deserve some recognition, and they get their convictions expunged. That's usually how that happens. Okay, so let's talk about Bruin for a second. In the state of Colorado, we got an older case, and I'm not going to remember the name offhand, but it's been around long enough that it is established law in this state that even if you are a convicted felon and you're not supposed to possess firearms, if you have a firearm available to you because you're defending yourself in your home or on your premises, but in particular in your home, uh, you can assert that kind of 2A defense against a charge of possession of a weapon by a previous offender, which is what the felon in possession charge is called.
Mhm.
Bruin seems to say you have a fundamental constitutional right to possess that firearm for self-defense. Felon or not, I'm not sure there's a meaningful distinction between Joe Citizen walking around defending himself with a handgun and a convicted felon walking around years after his conviction wanting to still defend himself in public with a handgun and wanting to possess that handgun concealed. I'm not sure there's a good distinction that makes sense in light of what we see in Bruin as this historical analysis they go through. They don't really tolerate. Well, number one, they never mention anything about the ban against felons, attempting to defend, possessing firearms, even for self-defense. They talk about sensitive places. They talk about dangerous weapons. They don't talk about dangerous people. And so I wonder if
Yeah.
that isn't something that could be be subject to challenge now, you know, probably after this thing kind of waterfalls down for a while and we see some of the large cap magazine bans, for example, get challenged and successfully challenged. I wonder if that's not down the road here where the waterfall is going to keep on rolling downhill and sweep away some of these sorts of prohibitions that don't make a
Correct.
lot of sense. Because I've had clients come back to me 20, 24 years later. They had some, weird felony when they were much, much, much younger. And I'm not talking about your ordinary, marijuana possession where they were,
Correct.
dealing, moderate amounts of marijuana. And, some of those are no longer even felonies. But I'm talking about people with actual felony convictions, and they've been not only rehabilitated, they got grandkids. They got, a place in the community. They're business owners. All these things in their favor, and they can't carry a handgun. They can't go, defend themselves in their business or in their homes with a handgun without risking that possession
Correct.
of a weapon by previous offender statute. So I wonder if this isn't another one of the house cards in the house that's going to get knocked down eventually.
Now, does it matter if the offense is a federal felony or a state felony? A felony is a felony.
Well, the definition is federal. It has to do with domestic violence crimes. Sorry, crimes of domestic violence under the federal definition,
Got it.
felonies under the federal definition, and then the state has its own sort of rules about state felonies and domestic violence.
Yeah.
But the federal, prohibition that we've had ever since Brady uses its own definitions about those terms, and every domestic violence case at the state level is not a domestic violence crime at the federal level.
Correct.
So if we have, a real common thing we have is someone gets in an argument. It's an argument with the wife. It's loud, it's boisterous, there's pushing and shoving back and forth, but the guy goes to jail. If he's a hunter, if he has firearms, all of a sudden, the new law is they have to turn them over immediately at their first advisement. They have to sign an affidavit. They have to turn the
Correct.
weapons over to a police department or a friend. They can't have access to any of them, and they have to indicate that not only have they given them up, but how which weapons they've given up. So it's a long, detailed affidavit they have to fill out and file with the court. Um, so just in terms of I think what we're looking at doing with all of those sorts of laws, those sort of restrictive um, surrendering laws, scratch that. In terms of the domestic violence crimes at the state level, someone who is convicted of harassment by pushing or shoving could potentially fall afoul of the Brady prohibition. But if you plead it down to telephone harassment, it doesn't count anymore. It can still be harassment as long as it's by telephone, and then it doesn't count.
So
So you just
stupid.
change to a subsection in that same statute, and it's fine.
Yeah, this is which shows you just how arbitrary all of this stuff is, and how
Very.
ridiculous it all is.
Mhm.
It makes no sense. It's laws for the sake of making laws. It's rules for the sake of making rules without any real direction, without any real. And that's where a lot of the gun owners are kind of just stuck in, like, what's real, what's not real, what's true, what's not true. And at least from the short amount of time that we've been teaching classes, and we've had to talk people off the ledge when they get into a situation where they
Mhm.
need an attorney, is even when you get stuck in there, some shit happens where you're just like, what? Like, that makes absolutely no sense.
Right.
Why it went this way or that way, because the law says this or the law says that. And that's why we encourage people to have proper representation ready. That's why it's important to get a hold of Brian, and make sure you um, have good advisement, and retain a good attorney. And Brian's here. He's been helping us out for a while, and here he is spending time with us again. Super duper important that you guys understand this stuff. But so the thing about the felonies is, there was one I had read previously, and I can't find it anymore on the ATF website because they change it so often.
Hmm.
Um, and I think that they sometimes do it on purpose. At some point, I had read something about restoring rights. That there were some prohibited people that can have their rights restored. Basically, everything you just said, but one of them was rights restored. Is that like a different category? Is that something that's just not very common, or um,
It is not very common because I haven't run into it before. Um,
so I'm gonna try and look it up.
yeah, if you could, because I'm not remembering the ATF providing additional guidance. I know that in the state, um, there is now a change in the law that offers the possibility of I have to think of. I think I have to think of this before I say it. There was a change in the state law that appeared to allow people to reinstate some of their firearms rights.
Hmm.
Um, I'm not even sure how that played out really because I haven't had to look at it a whole lot. So I don't want to talk a whole lot about it, unfortunately, until I know a little bit more. I can go into it and we can talk about it next time. But there was a push to expand the number of convictions you could seal, and then there was a push to perhaps what it seemed to indicate was you could reinstate firearms rights for a real small subset of people with disqualifying convictions under state law. Now I don't know what that meant federally because the federal definition, to be honest, is much narrower than what we have here in the state. And CBI treats domestic violence convictions as uniform, and isn't as careful about looking at what the convictions actually are and why they would fall under the federal definition and statute. Um, and they don't like to be challenged on it. Um,
Correct.
so um, I've got a case running in front of the Court of Appeals now where we're trying to challenge exactly that, the definition in the statute, the process that was followed in the state court, and the lack of any nexus to a domestic violence, conviction, which requires that the conviction be for the, at least for the state, under the state law, be for the purposes of intimidation or abuse. And there just was nothing like that in the case that we had. So, uh, um,
Oh, I just found it. They stopped accepting applications. So like at this point there's no more. So you can't even pretend to apply to restore. Um excuse me. So at some point it was a possibility, and now it's those ways that you say that you were talking about.
yeah,
Because you have to apply for the restoration of rights through the ATF,
yep.
and the ATF has stopped accepting those applications.
Yeah, I just found the exact same thing. So there was a federal law passed that allowed you to apply for relief from that firearms prohibition. The appropriation since 1992 has prohibited expending any funds to act upon those applications. So since
Conveniently.
1992, there hasn't been a dime allocated to that program. So that's why there are no such applications. Can you imagine? That's what it comes down to is we're not going to we will pass the law that allows you to consider these applications, but we're just not going to pay you.
We're not going to fund you to
We're
do
not
it.
going to fund you to do any of them.
That's crazy.
A little bit, yeah, that's a little crazy.
I will
Um,
start a GoFundMe for that. Uh, that seems like a worthy cause. So,
yeah.
anything else that you wanted to add, Brian? Anything else that you want to tell the people? I know
Oh,
there's so many things. There was one thing, but I think we'll hold it off for the newspaper. This month's question
mhm,
is for the newspaper. For those of you that don't know, we do have a newspaper, the Guns for Everyone Gazette. Brian writes an article every month for it. Um, and it's basically a quote unquote Ask the Attorney series.
mhm,
This month's question was posed in its if I am a prohibited person, which is right on track with what we're talking about. If I'm a
yep,
prohibited person and I use my firearm in self defense, and I believe it was in or outside the house. Either way, what are the implications and all that stuff? So I think we'll leave that for the viewers so they can read it and kind of go catch that newspaper.
Right. Right
Um,
on.
yeah, is there anything else that you wanted to add? Anything else that you've thought about while we're doing? Yeah, go for it.
Couple of things. So, in terms of the RMGO lawsuits, some of that stuff is available online if you just sign up for a Pacer account. You can see a lot of that stuff, the filings, the court scheduling orders, the dates
What
of
is
any
Pacer?
hearings. Oh, Pacer is the federal electronic filing system. It's available
Okay.
nationwide for almost any federal case, and but it's publicly available. Uh, it is a wealth of information usually. And if you can figure out when those cases, usually it'll have a calendaring section of the website that shows you when the cases are coming up for oral argument on the injunction or the uh, case management conference. Some of that stuff is publicly available as just video feeds, so you can watch like court TV. You can in state court. Almost every single courtroom is now live on WebEx or Microsoft Teams, and you can watch almost any court proceeding, my trials, any case you've ever heard about in state court. You can just figure out when they're going to be on, and then track figure out the WebEx link to log into the courtroom to watch it.
Yeah. Okay. And this is all available on Pacer.
Well, so Pacer is the federal system.
Got it.
Federal
Got it.
court was offering some WebEx or video appearances. I don't know how many of those hearings still are by video, but some were. Uh, so you might be able to catch some of that stuff. If nothing else, you can just update yourself on what's going on with the cases.
Okay. Cool.
Um,
Cool.
so that's a good source of information going forward. I know, or, so oddly enough, I've had cases in the past, and I've had a case now with one of the attorneys that's working for RMGO. So we might want to invite him on one of these times. It's Pearman. Invite him on just to talk about the process that they're following, the progress of the case, what they expect to happen next. And he may not honestly be able to answer a whole lot of questions because it's a pending case, but he'd be an interesting guy to talk to.
That'd be great. So if you know him, I didn't know that you guys were.
We've had
Uh,
cases against each other. It's if you understand, like it's
yeah.
boxer like boxers in a ring. Like I know that guy, but I don't know him. That's what it's like.
Oh man, so true. Um, uh, because the other thing is we talked about is, and I'm just going to kind of preview this. RMGO agreed to help us this time to sue. Well, we haven't started that, so I guess suing is not the proper term right now. But sent a letter of cease and desist to Rio Grande County down in southern Colorado
All right.
for adding requirements for to the permit process.
Yep.
So they are requiring students to do live fire, which is not a state requirement. Colorado does not require,
Mm-hmm.
and nor did the preemption law from last year change the requirements for concealed carry in any way, shape, or form. Um, so Rio Blanco is actually acting unlawfully, has been acting unlawfully for quite some time. So we went down there and I had sent the sheriff a few emails. I believe I forwarded some of them to
Mm-hmm.
you to kind of just get ready. And
Yep.
they he got quiet after a while. Um, the sheriff down in Rio Grande when I challenged them, I don't think they're used to people really challenging them and um, wanting to get answers from them. But at any rate, after our dinner, RMGO said that he'll send them the initial cease and desist, and then we'll see what happens from there. But look for that as well. The deposition that that you did last time was especially the few second clip of Justin Smith acknowledging that he doesn't train his people and the lady admitting that she doesn't
I've
read the
never
laws and
read the
doesn't
statute. No,
correct
no.
because he doesn't write it. So those are it's crazy, the crazy stuff. So
So
I think
when
your mic is caught up on. Oh, there
oh
we go.
sorry.
Yeah.
So here's what I'll say about that. So Bruin is exactly the obstacle the Rio Grande sheriff has to leap over, right? Because it's almost exactly the same issue. In New York, it was whether or not you could publicly carry, and in Rio Grande, it's the issue is whether you can publicly carry, right? Concealed weapon in public, carry for self-defense. And what they're doing is not the same thing as what was happening in New York, which was they're just denying 99% of the applications. But Rio Grande now is violating not just the state law, but constitutionally, they're violating Bruin, which says there are no restrictions you can put into place that make sense if the
Correct.
historical analysis is all I have to look at. Historical analysis says, could you carry a weapon concealed um, from the beginning of this country until now? And the answer is yes. And nowhere in there does it say the Rio Grande sheriff gets to impose additional obstacles you got to jump over like a live fire exercise. That's not in the statute.
Correct.
That's not in the Constitution either. He doesn't get to do that. He
Correct.
doesn't.
And the state statute actually very specifically
Yeah.
prohibits him from adding any further requirements. So that's going to be interesting. We'll see what he does. It seems like he's not ready to fight. He's not ready to communicate. He's not ready to do any of that stuff. So we'll see what happens there.
Yeah, I can bet he had a sit down with the county attorney, and they probably decided cost benefit on something like that is not in their favor. That's probably the way it
I
went.
would hope so because they haven't responded.
Hmm.
So either they're just going to pretend it didn't happen and very quietly start accepting a lot of certificates, or or maybe we're wrong and they feel like it's worth it to them, which is
I'd be surprised.
very
A lot of those sorts of restrictions are not going to stand in the face of the Bruin case anymore, and not anymore. Not anymore.
it's gonna be tough.
Yeah.
And this is why it's so important for us to get that declaratory injunction, right? It just anywhere like
Hmm.
it's just super duper important
Hmm.
for people to fight this and not if this does happen to you, fight it, take it to court,
Right.
sue these people, because now you have something saying you're right, it should not happen again, and now we have a case. Because I don't think it exists. I really don't think in Colorado there's a case law where it's been taken to court and the sheriffs have been
No.
prevented from like I've never seen something like that at a state level. So it's gonna be interesting. But if you've got nothing further, I've got nothing further. This was
Okay.
fun. It was kind of weird. It was it's been a while since I do this. So like I'm a little lost to be honest with you, but like it's nice to get back on here and next time I'll remember where the buttons are at and all that stuff. So this was kind of weird, but it's nice to get back in here. So
Heck yeah, it
um
was. It's a pleasure always to be here.
yeah, absolutely. So I appreciate everybody. I'm going to try and do this on a regular basis. If it's just myself, it's not going to be an hour and a half. If we have guests, definitely it's going to be this long or maybe even a little bit longer. We'll have Brian on as much as we can and answer your questions. And don't be shy to DM us or send us questions throughout the month. That also helps the newspaper. Remember, go to denverlawshark.com. Especially if you have one of these weird triggers that the ATF is asking a lot of questions about. Go donate. I put our link tree in the comments. Please go donate to Brian. He spends a lot of time um, doing this type of stuff, classes, educating the public for free, and it's free to the people, but it's not free to him. So please go donate to him, go send him some money and support him, retain him, do all that stuff. So anyways, I appreciate you guys. I appreciate you guys' time. I appreciate the comments, the questions, and the support.